Welcome back to the People's Courtroom. Let's read the file, because this week, the file did something files almost never do. It moved 3 times in 24 hours, in 3 different courts, and every single move said the same word. Nobody lied about this one, jury. Nobody had to. Today's case is not a correction. It is the record itself, and the record is a thing of beauty. So phones on silent, brains on. Here is what happened while you were busy. The docket read plainly. Tuesday. The Supreme Court of the United States denies certiorari in Trump versus Carroll. No opinion, no noted dissent, not one justice wanted to hear it. Wednesday. Judge Lewis Kaplan of the Southern District of New York orders the escrowed judgment released to E. Jean Carroll. Wednesday night. The Second Circuit denies the emergency motion to stay it. That order, ladies and gentlemen, is 1 page long. 3 courts, 24 hours, 1 answer. Now, the underlying findings, and precision matters here, so I will say it exactly the way the verdict form did. In 2023, a federal jury found Donald Trump liable for sexually abusing E. Jean Carroll in a Bergdorf Goodman dressing room in 1996. Sexual abuse under New York law. Those are the jury's words, not mine. The same jury found he defamed her when he denied it in 2019 and awarded her $5 million. None of that is new this week. What is new is simpler, and in its own way, bigger. This week, the money moved. Here is what 3 years of stalling actually bought. After the verdict, the money went into escrow while the appeals ran. To the Second Circuit, then rehearing, then the Supreme Court. Every stop bought a few more months, and at every stop, Carroll kept waiting for a judgment she had already won. But escrow does one quiet thing the defendant cannot appeal. It earns interest. $5 million became roughly $5.8 million by the time the courts finished. 3 years of the finest legal delay money can buy, and the delay changed nothing except the size of the check. And then there is the sentence a federal judge should almost never have to write. Judge Kaplan, ordering the release, wrote that it is time for the defendant to do equity, and that he, quote, has been stalling this case for years. Do equity. That is the phrase a court uses when the arguing is over, when a party has exhausted the last procedural hallway and the only move left is the one it owed from the very beginning. A judge does not often need to remind a litigant that judgments are not suggestions. He needed to this week. And within hours, 2 courts above him agreed. Now, why should you care about one plaintiff's check, jury? Because of the question sitting underneath it, which was live, constitutional, and had a dollar amount attached. Can a president outweight a civil judgment? Can enough money and enough lawyers appeal a verdict into old age until it simply never collects? That question got tested this week by the most resourced defendant in America, in every court in the country, and the answer came back in 24 hours, unanimous by silence, 1 page long. No, the judgment collects. For every plaintiff who will ever stand across from a defendant rich enough to run out the clock, that page is the precedent that matters. And do not let the clean ending erase what the 3 years cost. E. Jean Carroll carried a verdict she could not collect through all of it. A jury had already spoken. The man it found liable for sexually abusing and defaming her sat in the White House calling her case a hoax, while his lawyers bought month after month after month. The system got there. It really did. And this week it got there emphatically. But justice that takes 3 years of stalling to collect is justice a defendant got to rent out first, and she is the one who paid that rent. From the docket. Because this court has watched the courts get misread before. Last week, we tried a national outlet claiming a judge defied the Supreme Court when its own article admitted the opposite. This week is the other half of the same lesson. The courts said what they said, all 3 of them, and no amount of framing, stalling, or appealing changed the record. And the file is not closed, jury. The second verdict, $83.3 million for the defamation campaign that kept going after the first jury spoke, is still on appeal. Still accruing its own interest. Still ahead. The meter is running on that one too. The verdict, which this week the courts wrote for me. A jury's judgment is not a suggestion, a presidency is not a shield from it, and 3 years of stalling bought exactly one thing, a bigger check with more interest on it. Tuesday, no. Wednesday, pay her. Wednesday night, 1 page, denied. E. Jean Carroll collects her $5.8 million. The $83 million question is still in line, and every plaintiff in America just watched the clock beat the money for once. Courts adjourned, jury. Keep your receipts. I'm Madeline, and this is Pixel Politics.